the postgraduate teaching department of law, Rashtrasant Tukdoji Maharaj Nagpur University, Nagpur, has organized a national webinar on Consumer Protection Act 2019 recent amendments. The consumer has the right to be aware of their rights. This is an important in order to protect them against market abuses and social injustices. 15th marks World Consumer Rights Day as a means of raising global awareness about consumer rights and needs. With the growth of online marketplaces and India's growth as a consumer economy, our government brought a new Consumer Protection Act 2019, which replaced the earlier Consumer Protection Act 1986. So the remarkable changes are there in the new act. Like in the first time, the concept of product liability is introduced. Okay. So the concept of product liability, and you can file online complaint or on e-commerce first time is introduced in new act. So these provisions and more provisions we are having with us to enlighten us on the recent amendments on Consumer Protection Act on 2019. We are having with us Dr. Ajay Sonawne sir, Assistant Professor, University of Delhi. Thank you very much. Over to you, Vinay.
Yeah, thanks a lot, ma'am. Just these instructions, just a little housekeeping before we get started. If you have any questions during the presentation of a resource person, please type them into the question box that is provided in the chat box. I will bring them up during the presentation, and we will show. We will also have time for questions at the end as well. Yeah, now let's have the pleasure to listening the opening remarks. May I request our Honorable Head of the Department, Postgraduate Teaching Department of Law, Rashtrasant Tukdoji Maharaj University, Dr. Payal Thaure ma'am, to please deliver the welcome address. Over to
Madam. Thank you, Vinay. Yeah, thank you so much, Vinay. A very warm welcome to our today's resource person, Dr. Ajay Sonawne. A very warm welcome to all the participants, my dear colleagues and friends. As we all are aware that the consumer movement, has started in India after the consumer protection, like before the Consumer Protection Act came into existence. But we all are very much aware that since 1872, when we had the Indian Contract Act, from that time we started understanding the concept of purchaser. But over the period of time, it took us probably almost more than 100 years to understand the journey from a purchaser to the consumer. And when we understand that a particular person who buys a good is not only a purchaser, but at the same time, he is a consumer, which means that there is an element of social welfareness as well as social justice, which is involved with it. And after we had the Consumer Protection Act, we have seen that in the year 2019, there has been some interesting developments which has taken into place, in this particular act. Initially, when the act was made, the role and responsibility most of the time lies on the consumer. But eventually, we have seen the gradual shift, a paradigm shift into the understanding of this concept of consumer. And now the liability and responsibility majoritarily lies on the vendors. Now, this is somewhere, we have seen that the element of social justice has been taken care of. And today we have an eminent resource person who is my good friend as well, Dr. Ajay Sonawne, who is going to enlighten us on this particular aspect. So, Ajay, first of all, I would like to extend my heartfelt gratitude for gracefully accepting our invitation for being the resource person for this particular national webinar. And I am sure that your expertise and your insights will certainly enhance the understanding of our students. So once again, I welcome you all, and I hope that my participants are going to enjoy this lecture. Thank you. Over to you, Vinay.
So please unmute.
Without further ado, we will turn the time over to our resource person. Today's our resource person is Dr. Ajay Sonawne. Let's have a brief introduction of our resource person. Dr. Ajay Sonawne is presently serving as an assistant professor at Law Center 2, Faculty of Law, University of Delhi. He did graduation and post-graduation in law from ILS Law College, Pune, and PhD from Department of Law, Savitribai Phule, Pune University. He was awarded with gold medal in LLM in the subject of law of contracts from Savitribai Phule, Pune University. He has served as an assistant professor in School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, Mumbai. He has also served as teaching associate of Human Rights Education Program and Department of Law, Savitribai Phule, Pune University, Maharashtra. He has organized and also presented papers in various national and international seminars and conferences. He has published articles in reputed journals and edited books on different subjects related to law. Presently, he is co-project investigator of research projects, Ministry of Tribal Affairs, Government of India, and Ministry of Women and Child Development, Government of India. So, over to you, Dr. Sonawne, please.
Okay. Yes, thank you so much, sir. Can I share my PPT here?
Yeah, sure, sir.
Just
Please.
let me know if it is visible or not. Yeah. Is it visible?
Yes, sir. Yes, the screen is visible.
Okay.
Yes, it's visible.
Okay. Okay, so first of all, thank you so much, Payal ma'am, for inviting me for this session and giving this opportunity. And so today, as we have this topic of Consumer Protection Act 2019 recent amendments. So in this session, that we are going to understand that what are the recent amendments that has been taken place in this Consumer Protection Act 2019 till, and even after that, there are few amendments that has been taken place with the few notification that has been published by the central government. So here, without any further ado, we'll start with the today's session. So as very well said by Mahatma Gandhi, that a customer is the most important visitor on our premises, and he is not dependent. He is not dependent on us. We are dependent on him, and he is not an interruption in our work. He is the purpose of it, and he is not an outsider in our business. He is a part of it. So we are not doing him a favor by serving him. He is doing us a favor by giving us an opportunity to do so. So as initially stated by our head of the department, Payal ma'am, that the term consumer, that it took more than 100 years to understand this particular term as a consumer, but ultimately the crux or the idea behind the rights of consumer was very well present in this decade, or you can say in this 100 years. So here, if we look at the changing scenario and how the concept of consumer that has basically inserted in our legal system. So the reason behind that was first that due to the fast global changes and the globalization of economy, the scenario of the term consumer, or you can say the scenario of the transaction which are happening between the seller and buyer, that has completely changed, because the issue that arise due to the changing nature of state as well as changing nature of the transaction and the technology, there was a need to have a particular law which can focus more upon the people who are using the product rather than people who are producing the product. Like in the USA, there was a culture, some of you might have been aware, that there was a culture of producer-oriented society rather than the consumer-oriented society, or the people who are using the product, or the buyer-oriented society that was not there. But at the when this idea of consumer, or the people who are consuming product or using that product, they are more important than the producer. Then this idea that was initiated even in USA, or like in India as well. So there was a shift from the producer oriented society to the consumer oriented society, or you can say the people who are using that product, they are the prime concern, or they are the more important for us. So looking at their perspective, or looking at their need, there are several laws that were already there, like prior to consumer protection law. Like for example, there was law of torts, sale of goods act 1930, prevention of food and adulteration act 1954, that was again after independence, then essential commodities act, then the MRTP amendment act 1984. So prior to consumer protection act, yes, there were several laws which were taking care of the buyers or their interest. But as very well said by, I think, if you have seen the jurisprudence, and there was a sociological jurist, Roscoe Pound, who has very well said the term, or who has defined the term rights in his own interpretation. And he has mentioned that rights are nothing but an interest which needs to be recognized, protected, and enforced by the law. Okay, so rights is nothing but an interest which need to be recognized first, then protect, and then enforced by the law. So this rights of consumer that we have, so this right is nothing but, it was already present somewhere in our legal system, it was already present in the society, but only the need that was felt to recognize that particular right. And the reason to recognize that right was that the laws which we had already, they were not very well sufficient. And as there was a shift of the laissez-faire era to the social welfare era, wherein the welfare of all, if you want to achieve, then there should not be such kind of a discrimination. There should not be a discrimination in a way that the seller should get, or entrepreneur should get more, you can say, the weightage, and the people who are consuming or people who are using that product may not get the opportunity to raise their voice. So therefore, in even at the international level, the United Nations even has taken this task in their hand to pass the resolution which specifically indicates the rights of consumer, and even the United Nations has termed as consumer right as a human right. So considering this aspect, they had set certain guidelines, and they asked the state to prepare certain, or they, you can say, they gave the, you can say, certain direction or certain guideline to the state, that they could make certain laws for the better protection of interest of the consumer. So finally, like in India, the first, that is the Consumer Protection Act 1986 was passed to give the better protection to consumer, because the term better protection is very important, because sometimes the people may ask that why the Consumer Protection Act is necessary, because already we have several acts. But the preamble of the act itself has given the justification for better protection of rights of consumer, we are having this particular act. So what is the aim of this act? The aim is to provide, protect, preserve, enforce, and give the speedy remedy to the consumer rights. and and there was also shift from the caveat emptor to the caveat vendor. So as we know that buyer be aware is the philosophy that was generally applicable even in the Contract or Sales of Goods Act or other previous acts. But now, after the Consumer Protection Act, there was a caveat vendor wherein even the seller has to take certain responsibility and seller has to act according to the law and act within the framework of this Consumer Protection Act. Moving ahead, so just briefly, what are the basic rights of consumer? So as after the enactment of this Consumer Protection Act 1986 initially. So these are the 6 basic rights of consumer that were defined in the act itself. The first is right to safety. Second is the right to be informed. Third is right to choose. Fourth, right to be heard. Fifth, right to seek redressal. And sixth one, right to consumer education. So here, when we talk about these are the basic rights and the initiative which was started by the then government, that is Jago Grahak Jago, that is nothing but that every consumer should be aware about their rights. They should be aware uh, about their rights in a way that if they face certain issues, certain challenges, then to whom they can approach, to whom they can uh, from where they can get their justice or their, you can say, the compensation. So for that purpose, these are the certain rights that every consumer should have in their mind, or they should be aware about it. So right to safety, so these are the basically 6 right. I think we all have studied in the act of 1986 as well. So just to give the context, I thought that these are certain rights that we can focus upon. Okay, and then moving ahead, now the important crux when we turn to our topic of the day, that what were the exactly loopholes in the Consumer Protection Act 1986 and the reason that was there to have this Consumer Protection Act 2019. So in that regard, the first reason behind having this Consumer Protection Act 2019 and the major loophole in the Consumer Protection Act 1986 was nothing but that the advancement in technology and the changing nature of state. Because as we know that the way society has transformed in last 2 decades, or you can say, so we have seen that there is a progress in the technology, there is a progress in the e-commerce, there is a progress in the electronic transaction, and especially in the last 2 years during the COVID pandemic, or in this when the city or the world when it was in the lockdown stage. So we have seen that how the e-commerce or e-transaction that has raised, and even the people have taken benefit of that e-transaction. But certainly at the same time, there are people who have faced certain issues and challenges as well during the e-transaction, because many a times when we purchase certain the products to the electronic transaction, maybe the mode like Amazon or maybe Flipkart or any other you can say transaction or the mode we have. So we have faced certain issues. Sometimes the consumer might have received different product, but there was no you can say the provision, or there was no specific law or legislation which was dealing with this e-commerce under the Consumer Protection Act 1986. So looking at the changing scenario or changing nature of state, this was one lacuna which was there under the Consumer Protection Act 1986. So therefore, there was no provision regarding e-commerce, or if there is a issue that is faced by any consumer while uh, purchasing the product from the e-transaction or from such e-platform, then there was no right to the consumer under this Consumer Protection Act. Second, another lacuna which we can see, that is the no jurisdiction to lodge a complaint where buyer resides. So in this 1986 Act, the jurisdiction that was specifically given, or you can say defined, only where the seller has its, you can say, registered office, or where the seller having its jurisdiction, so only their complaint can be filed by the buyer. So again, this was another lacuna, because the problem that used to arise is that when the buyer has to file a complaint, then buyer has to go to the seller's you can say the jurisdiction, and there he has to file the complaint, and then proceeding will initiate. So that was little hectic, or you can say that was wasting a time and energy for the buyer. So therefore, no jurisdiction that was there to lodge a complaint where the buyer resides. Then next point regarding the independent regulator. No independent regulator. Now here this we have under the Consumer Protection Act 1986, if you remember that we have several commissions and several councils which are basically looking after this implementation of Consumer Protection Act. So commissions or the tribunals which are there, they look after the adjudicatory part, and there are councils which are there to see that whether there is a proper implementation act or not, and they can for that purpose they can give certain suggestions, certain recommendation to the central government or the state government. So here but this council were not having any you can say the administrative power, in a sense that to punish someone or to give some or in case if some seller is not adhering to the guidelines or the rules of Consumer Protection Act, then this council were not having any power to punish or to give any punishment. So here there was this particular council was lacking on this particular aspect, that every time if they find that there is a no proper implementation of law, then they have to approach to the they will just give the recommendation and they will submit to the state government and central government. So ultimately the the purpose of council was only recommendatory and the as a suggestion, but they were not actually taking any effort to implement that law, or they were not having that power, that is a deterrent power that was not there in the hand of the councils. So for that purpose, there was no regulator or independent regulator other than the commission. And commission, what commission will do? Commission will only act when the complaint will be filed by the consumer after exhausting all the remedies which are available. So that was again lacuna. And the third, or the sorry, the last one is that no provision related to the alternative dispute resolution. So as you can see that in today's context, the judiciary is obviously acting as an one of the important you can say the element to resolve the dispute between the parties. To assist the judiciary, we have a tribunals or like the commissions or the forums, the district earlier the district forum, state commission, and the national commission, which are there under 1986. But now, as the nature of legal system that are now transforming, and wherein the as according to the even which is according to the law of this CPC, wherein the section 89 of CPC which recognize this idea of alternative dispute resolution. So to resolve the dispute between the consumers, there was no provision as such which was mentioned under the Consumer Protection Act 1986, that the dispute can be resolved by way of alternative dispute mechanism as well, which may include the mediation or conciliation, negotiation in that manner. So alternative dispute resolutions are playing a significant role in today's context. And even if you might have observed that even in the High Court or several district court or even the Supreme Court, the MCPC, that is Mediation and Conciliation Project Committee, which has been specially established, and they are taking care of this mediation process, shall be utilized to the maximum the parties, so that this mediation or the conciliation shall be the effective mechanism, and the dispute can be resolved outside court as well, rather than like every party shall approach to the tribunal or the court. Even they can resolve the dispute outside court. So looking at the today's context, many parties are taking benefit of this mediation process. So looking at that aspect, there was no provision as such in the 96 Act of this Consumer Protection. So these were certain loopholes which are practically, or you can say that were there in the prior to this 2019 Act. And so to answer all those queries, or answer to or to resolve, to give the solution to all those loopholes, the Consumer Protection Act 2019 that came into existence. So initially this Consumer Protection Bill, so this is just a brief factual history that the Consumer Protection Bill 2019 was introduced in Lok Sabha by the Minister of Consumer Affairs, Food and Public Distribution, the then late Sri Ram Vilas Paswan on July 8, 2019. So the bill replaces this Consumer Protection Act 1986, and again the aim of this new act is to the protection of interest of the consumers, particularly those grievances arising in post sale of goods and services. So the more or less the you can say the objective of both the act are quite similar, and but in addition to that, provisions which are there inside that has definitely added or they have been increased. So and to further to provide a simple and quick solution to consumers for their grievances against any deficiency in services or defect in goods. So basically the goods and services, these are the two important aspects that we have to remember when we talk about consumers. So either what the goods you purchase or the services which you hire or take from any other seller or some other party. So for that two purposes, if you find any deficiency, any defect, any wrong, then the law is there, or the Consumer Protection Act 2019 is there, which can provide a simple and quick solution in this regard. So here now, we'll see now what are the exact recent amendment that has been taken place and how they are been defined in this particular act. As mentioned by Padma ma'am initially, there are few amendments, and so I have just highlighted this in brief. So first, recent amendment or the amendments which are there in the Consumer Protection Act 2019 are: number one, inclusion of e-commerce; second, establishment of Central Consumer Protection Authority; then strict norms for misleading advertisement; then strict norms for product liability; then consumer redressal commissions and their jurisdiction; then the new term that was again added, that is unfair contract, which is under the unfair trade practices; and the most importantly, the alternative dispute resolution through mediation. Okay, so these are the few, you can say, the uh, significant areas in which this particular Act 2019 having this features, and so we'll see one by one exactly how these areas that has been covered under this Consumer Protection Act 2019. So when we look at the first one, that is inclusion of e-commerce. So as we know that, as we discussed, now that e-platforms are now became the very significant part and parcel of life of each and everyone. Initially, this idea was the e-commerce that people were not like in the favor, you can say, or they were not aware about the benefits of this e-commerce or e-transaction. But nowadays, there are people who are preferring to purchase the products from the e-resources, that definite what or e-platform that we have. So therefore, it was a need of an hour to have certain remedies in case if there is any violation, to have certain remedies in case of any violation of interest of the purchaser. So this new amendment includes the customers who make purchases online, and for that purpose, the new set of rules that has been framed or that has been inserted in this act of e-commerce platforms. So here, what is the exactly required by the seller? As we are looking at, it is the caveat vendor. So the seller has more responsibility than the buyer. So what exactly seller has it is expected to do under this new act? First is that he need to disclose the address and other details of the seller. Then to ensure that no fraud or counterfeit products are being sold on e-platforms by the respective companies, because even in the newspaper or in the news channel you might have seen that there are certain consumers or the buyers, when they order something on the different e-platform, maybe Amazon, Flipkart, Big Basket, etc. So they order, like if someone want to buy a mobile phone, if they order the mobile phone and they receive something else, maybe soap or something. So in that case, in such situation, where one can approach or where the consumer can approach. So here for to get the information that who has sent that product, who was the seller, what is his address, or where this from which area this soap has been sent instead of mobile, where is the shop, so who is the vendor, so all the information has to be there on that e-platform, and accordingly the individual, or you can say the person, the purchaser will have the right to claim for his compensation in this regard. Then further, that the refund and exchange policy also shall be clearly mentioned, because many a times that people, like even in the online transaction, they purchase certain product and they may not like that product. So in that case, what is the refund policy? What is the exchange policy? So all these things that has to be mentioned in the that you can say the e-platform itself, because sometimes there are certain products may not be exchangeable, certain products may be refundable, may not be refundable. So that clarity has to be there. If that clarity is not there, then there is a chance that one can approach to this appropriate authorities, or they can approach to the appropriate authorities, and they can come to the consumers as well. And here the I think many of you might be aware, or some of you may not be aware, that when it comes to the Consumer Protection Act 2019, or even 1986, there is this act is specially enacted with some simple procedure, or without any complex, or without any you can say the complex procedures are not there. There is a flexibility, and even the judge or the member of this commissions, even they are following the simple and you can say the non-complex procedures. So in that, in addition to that, there is no need of advocate as well. Even individual can directly approach to the consumer, and they can file the complaint, and even they can argue their case on their own. So the advocate is not necessary, which is not mandatory in this process of this consumer cases. So looking at all these flexibilities that what we have, so even if someone face any kind of issues when it comes to the e-commerce or any other issues, then they can directly approach to the consumer forum, whichever are wherever they resides, and uh, that this power has been given by the act itself. And the next important aspect which has been added, that is establishment of Central Consumer Protection Authority. So this Central Consumer Protection Authority, or this is basically a regulator. So such provision, which it was not there in the 1806 Act, as we have seen, this was one of the loopholes. So here, the Central Consumer Protection Authority is the pure example of the administrative authority, and this authority has the power to implement the laws. It has a power to regulate and even the conduct the inquiries into the violation of consumer rights, or if any false or misleading advertisements. And in addition to that, this Central Consumer Protection Authority will have a power to take suo motu action. So he can take, so if he finds that if there is any misleading advertisement, if there is any false advertisement, then this Central Consumer Protection Authority will have a power to intervene and ask to such endorser, or such you can say the manufacturer, or you can say the vendor, seller, whoever is there, whoever is responsible for that misleading advertisement. This Central Consumer Protection Authority will have a power to intervene and ask them to stop such advertisement, or even he can take the necessary action. So here, to take necessary action, it means that even the power has been given to the Central Consumer Protection Authority to impose penalties whoever disobey the laws or the provisions of the Consumer Protection Act. And even this CCPA has the power to investigate in the matter. So when he does the inquiry, he has his own independent investigative wing to investigate in the matter. So all these provisions were not there in the 1986 Act. So this CCPA is something which is very you can say the powerful authority that we have under this Act of 2019. And this Central Consumer Protection Authority also have a power to impose a fine, as well as even he can if it is not fulfilled, then even he has a power to send the person who has not adhered to the provisions of the act or his order, to send him in prison. So this ultimately, the Central Consumer Protection Authority is not only you can say the suggestive or recommendatory body, but this body is having the executive power as well as adjudicatory power in case of any such violation of consumer rights or any false or misleading advertisement if it is published by the any vendor or any endorser, etc. The another important amendment which has been added here is that this CCPA, in case if any party is not satisfied with the decision of CCPA, then they can file before the National Commission within 30 days. So this provision is also has been added that CCPA, agar in case if the someone is not happy with the decision of CCPA, not satisfied, then he can file an appeal before the National Commission. So there is a, you can say, the principle of natural justice, or you can say the basic principle that has been taken care, so that CCPA shall not get the wide discretionary power to take action according to in his own wish and whims. So there is a appeal. The provision is there that one can approach to the National Commission within 30 days. Then another important aspect which is very essential and nowadays, that which is creating impact over the several consumers or several people who are you can say the using different mobile or social media platform or any other platforms. So the advertisement is such that it is one of the mode to grab the consumer attention. So to make the consumers more you can say the you can say attract towards the product, so that this advertisement is one of the mode that has been very usually taken up by the different endorser or different product different owner of different products. But uh, there are certain examples as well that the uh, people have become you can say the fooled because of such wrong advertisements, certain misleading advertisements, certain misrepresentation which has been done by the endorser or the owner of the product. So therefore, even this particular Act 2019 has taken care of this misleading advertisement, and they have strictly defined certain norms and the consequences in case if there are certain false or misleading advertisement that is shown by the manufacturer or the advertising agencies. So what are the you can say the grounds? So first, if there are certain falsely describes such products or the services, or gives a false guarantee to, or is likely to mislead the consumers as to the nature, substance, quantity, or quality of such product or service. So in that, one can, with the justification, with the claim, one can approach to the forum. Because I think there was recently, after this enactment of this act, there was one case which had came before the Kerala district. In Kerala, there was in district commission, there was case which had came that there was an advertisement which was shown on television regarding the oil product. Like if you use this particular oil, then your hair will grow in just 7 days. So he used that product 2 weeks, not only 7 days, but 14 days. But there was no result. Then he approached to the this district commission by stating that this was the false guarantee that was given in the advertisement, and for that we need a compensation, whatever loss that we have suffered. So obviously the district commission granted the compensation, looking at the advertisement, looking as at the result and his justification, and then this compensation was granted. So ultimately, the misleading advertisement is now a danger. And even like if you might have observed recently, even on the television, the advertisement which has been published or which we see, they have now very carefully that has been prepared. So nowhere they will give the guarantee that we are giving the 100% result out of this particular product. They will say this is one of the better option, one of the best option. So they will not say that this is the best option, or this is the only option, or this is which will give you the result. This is the option. It is up to us that whether we have to use it or not. So ultimately, this is the nothing but outcome of this particular act, that misleading advertisement. Then further, it says that conveys an expression or implied representation which, if made by the manufacturer or seller or service provider, would constitute an unfair trade practice. So, in case if there are such misleading advertisement, even they will come under the the unfair trade practices. And deliberately concealing the important information, again, this will come under the misleading information or advertisement. Now, who are basically liable under this misleading advertisement? Then there are manufacturers, advertising agencies, even the celebrity endorsers. Okay, even the celebrity who we see that in the different advertisement, even they display or shows or give certain wrong information or such wrong interpretation or misrepresentation, then in that case even they would be liable under this particular misleading advertisement provisions. And even the publishers as well. And even this consumer protection authority, Central Consumer Protection Authority, can regulate all these issues regarding the misleading advertisement. This Central Consumer Protection Authority will have a power to take action against such manufacturers, advertising agencies, celebrity endorsers, and the publishers. And he can even ask them to pay the compensation up to 10 lakhs. And in case if it is a subsequently if they commit the same wrong again, then even that will go up to the 50 lakhs. So the point here is that the Central Consumer Protection Authority is something that as a tool or one of the important regulator which we have for the better implementation of this particular act. Then we have another important aspect that is regarding the product liability. So here, when we purchase any particular product or when we consume any particular product, then if that leads to certain injury, certain loss, certain damage because of the defect of product, because of the defect of service, then this particular concept of product liability is nothing but this particular in these circumstances, this concept plays an important role wherein it gives the right to claim the compensation for whatever loss, whatever injury, whatever damage which you have suffered because of the defective product, because of the defective service, okay, that is given by the manufacturer or the service provider. So for this particular purpose, earlier we had the regular civil courts that one can approach to the civil court and ask for the compensation, like in the case of law, like in the subject of law of torts, you might have heard the case of this Dunek versus Stevenson. So the parties that one can approach to the civil court for the in case there is a manufacturer negligence or manufacturer's liability, but and that takes years to come the conclusion or get the justice. But now product liability is there, which has been now extended to all the service provider and sellers along with the manufacturers, so that they can get the quick remedy, they can get the quick justice. So this concept of product liability also has been added in this particular uh, uh, act, so that they can get the right to claim the compensation. But at the same time, under section 87 of this act, there are certain defenses that are available for the product liability action. So the manufacturer, service provider, or seller, even they can take help of these defenses when when this product has been in case if they have been there is a complaint regarding the product liability, so they are having their defenses as well. So and moving ahead, another important aspect that we can see under this act regarding the adjudicatory bodies, that is the consumer redressal commissions. Now here and their jurisdictions. Now here there are amendments that has been taken place at two stages. One is the territorial jurisdiction and second is the pecuniary jurisdiction of these commissions. So this is the three-tier quasi-judicial mechanism for redressal of consumer dispute, which has been renamed as the district commission. Earlier it was district forum, and the two, that is state commission and the national commission. So this district commission is situated at the several districts, even the same state commissions at the several states, and nationally at the central level at the national commission. And this commissions provides for filing the consumer complaint electronically as well. So if you visit this e-Dakhil portal, so there are different portals that has been initiated at the district level, at the state level, at the national level. But I think during this 2 years of pandemic, this has not been implemented 100% in every district or every state. There are few states that has now started to take up the electronic complaints, because many consumers are still not aware that one can file the electronic complaint. So, but yes, the portal has been, you can say, the initiated, or that has been started by the few state, and wherein this portal take care of the e-notice or the case documents or the video conferences linked with the member or the consumers or the chairman of the commission, and even the filing the written response by the opposite party, or even the filing rejoinder. So all the process can be done by the online mode as well. So this from filing the case till the judgment, so all the process can be done through the video conferencing. So, but yes, the looking at the infrastructure and looking at the 2 years of pandemic, this electronic facility has not been utilized to the extent which was expected in the year 2019. And another recent amendment which has been taken place, that is the as we know that there is a pecuniary jurisdiction which was defined in the 1986 Act, that if one has to claim up to the 20 lakh rupees, then it's the district commission one can approach to in the according to 1986 Act. Then it is a state commission that is above 20 lakhs to 1 crore, and then there is a national commission that is above 1 crore. So this was the uh, you can say the pecuniary jurisdiction according to the uh, Consumer Protection Act 1986. Coming to the Consumer Protection Act 2019, as our today's topic is, it was defined under this act, that is up to 1 crore one can approach to the district commission. Then above 1 crore to 10 crore one can approach to the state commission, and above 10 crore one can approach to the national commission. So this was there in the year 2019. But recently, just 3 months back, if you have read in the newspaper also, that on 30th December 30 on 30th December, the center has notified a new rules, and they have revised the pecuniary jurisdiction as a sharp move which is aimed at the fast disposal of cases and reduce the burden of district as well as state commission. Because what used to happen when it comes to the up to 1 crore, then majority of the cases that has to be dealt by the district commission only, and therefore district commission became like they became overburdened due to the number of cases we started filing between this era. So therefore, on 30th December, the pecuniary jurisdiction that was amended, and now center has given this new pecuniary jurisdiction or revised pecuniary jurisdiction of the district commission, state commission, and the national commission. So when it comes to the district commission, it is up to 50 lakh. When it comes to the state commission, it is more than above 50 lakh up to 2 crore. And when it is national commission, then it is beyond or up beyond 2 crores or more than 2 crores. So this is the new rules or that has been published by the center. So at present, if one has to approach to the district commission, then it is up to 50 lakh. They can take up the cases. Similarly, state commission above 50 lakh to 2 crore, and the national commission above 2 crore. So this is the today's scenario, which has been changed just 3 months, not 3 months, even like 2.5 months back. Okay, and that was the reason behind, was that just to get the speedy recovery or the speedy disposal of cases, speedy justice to the at the district level as well as the state level. Okay, and so this is very important. And then we have this unfair contract has been inserted under this act, because this concept of unfair contract, which we can see at the several places or at the several different areas or different laws, but this Consumer Protection Act again has been recognized for this unfair contract, wherein there are contracts which are in the favor of service provider or manufacturer. This concept should not be there. So there should be, to protect the interest of consumer, the unfair contract uh, has been defined, and which are the areas, which are the clauses that should not be there in the contract, that has been defined by the act itself. So the term unfair contract, that or the conditions such as the requirement of an excessive security deposit by the consumer in for the facilitating the performance of obligation under the contract. Again, that will term as an unfair contract. Then imposing any penalty for breach of contract on the consumer. Again, that would be an unfair contract. Then not accepting early debt repayment along with the applicable penalty. Again, it will fall under the unfair contract. Then allowing one of the parties to terminate the contract without any reasonable cause or unilaterally. Again, that is not a part of the fair contract. And then entitling one party to assign the contract to the detriment of consumer and without his consent. And the last one is imposing unreasonable condition, obligation, or charge on the consumer that puts him in a disadvantageous position. Again, that would fall under the unfair terms of contract, because all this will fall automatically under the category of unfair trade practice, uh, which is not allowed, or which is not made it legal by the different laws. And the last change that we can see under the this Consumer Protection Act 2019 is that regarding the insertion of this alternative dispute resolution, which is nothing but the mediation. So now this mediation process is basically implemented in such a manner that if the consumer forums like state commission, district commission, or the national commission, if they find that this particular matter has been, now it is suitable to refer to the mediation cell, then they can do it at the any stage with the consent of the parties. So here there are consumer mediation cell has been established or should be established at the district commission and state commission as well as the national commission. And what this cell will do, this consumer mediation cell will maintain a list of impaneled mediators, because there are certified mediators who has completed their course of a mediator, so they can be a mediator in this to resolve the dispute between the parties. Then this impaneled mediators, then cases handled by the cell, record of proceedings, and other information by the specified regulations. So here the parties at any stage of the complaint can opt for the settlement through the mediation. And nowadays there is a new concept even that has been you can say the recognized, that is nothing but the online dispute resolution. So a party may be sitting in India, other party may be in at the other country, or one may sitting in Maharashtra, one may sitting in Delhi or other state. So online dispute resolution is again taking lead in resolving the dispute between the parties, because this again saves the time, energy, and now we have a sound technology, or you can say the fast technology. So taking benefit out of it, even the dispute have been resolved by way of this online dispute resolution method. So this mediation process can be done with the help of online dispute resolution. So wherein the one mediator will be there, and both the parties will put their issues, concern. The mediation will give the opportunity to each party, and accordingly, we will come to a particular conclusion. And the one more point that is just mentioned is that no appeal lies after the settlement of dispute through the mediation. So once the situation has been reached to the win-win situation, then there is no appeal will lie on the same concern of the on that issue, because if they are not coming to certain conclusion, then again commission is there to look after that matter. But once they have reached to conclusion, once they have satisfied with the suggestion or the conclusion which has been decided during the mediation process, then there is no again time for appeal, because court will not see the same matter again and again, waste their time in this particular matter. So here, this is the mediation process again that is helpful, because there are certain petty issues for which the commission or the court shall not waste their time, which can be settled outside the court only, and there is no formal or strict procedure even that has to be followed under the mediation. So finally, to conclude this presentation, we can say that the this enactment, this Consumer Protection Act 2019, is a dynamic step towards the fulfilling the you can say demands of the changing nature of state. Again, uh, you can say to have a pace with the advancement of the science and technology. It has focused to save the time, money, energy, and it is the best hope for the speedy justice delivery system. Only the thing is that we should have people or as a consumer, they shall be more aware about this act. They should get educated. They should inculcate this rights, whatever which has been defined under the act, and they shall take benefit out of it, because ultimately the better implementation is also necessary for the better protection of consumers as desired in the preamble of this act. So the implementation will become better only if the obviously the state, if when they will provide all the infrastructure, and obviously when the people are aware about their rights, then only this implementation can be a better one. Otherwise, merely just pointing out the state will not benefit, will not like turn the implementation better. So even people should be aware, and even the state should provide the infrastructure, and then this goal can be achieved, that which is given in the act, that is better protection of consumers. So thank you so much. If there are any question or any clarification, we can discuss.
Yeah, thank you, Dr. Sonane. We will go ahead and take some time for questions now. Are you ready for?
Yes, sir. Yes.
Yeah, just a reminder, please be sure to type your questions into the question box in your control panel. I guess it looks like we have a few questions. So I would like to ask you, first of the question which is here, can we bargain over the fixed MRP in mall?
Okay. Yes, actually, we have a right to do that. Actually, according to the, if we go by the Consumer Protection Act, we have a right to go by the fixed MRP that we have. But the bargaining is obviously when it comes to the mall. Then, if the price is not justified one, which is if they are charging something disproportionate, or which is something not proportionate with that, then obviously the individual has a right to ask for the price that has to be there according to the price which is mentioned. Because if you recently that if you see the on the airport that they supply the water bottle. So nowadays the water bottle, the Bisleri basic water bottle, they are now charging only for 10 rupees. Earlier they used to charge 90 or 100 rupees, but now they have started to sell it only for 10 rupees. So that is something that the basic MRP for the basic product or for the regular product, they are keeping with the price which is the basic one. So in case if they are charging something disproportionate, then obviously it is the people have a right to deny to purchase such product as well. Then yes, sir. Next.
Yeah, well said, sir. There's one more question. That means in standard contract, a person is binded with terms and conditions and cannot bargain or negotiate on particular product. Is there any exception to that to this contract?
Only the exception would be that if the clauses of contract, if they falls under the unfair category, or if they are unfair terms of contract, then obviously they can bargain and negotiate, or they can challenge with that particular aspect in the court of law. So that is what the exception we have in case if there is a unfair terms of contract. Yes, sir.
Thanks, sir. Then one more question is there is there a difference between forum and commission?
Okay, so in the context of this Consumer Protection Act, now earlier the term forum was used in the Consumer Protection Act 1986, but now it has been renamed as a commission. So it is just nomenclature has been changed, but the power, function, duties are same. So forum is just, or the commission, they are basically the quasi-judicial authority. The terminology has been just renamed, so they are same at present. Or it is we are calling it as a commission, but not a forum. So today we can use the commission. Yes, sir.
Yeah, okay. And sir, are you ready for a couple of questions again?
Yes, no issues.
Yeah. Any remedies if local retailers or in train charges above MRP?
Okay. So are unwillingly agreeing while signing an application using
Yeah, after that.
after that, any remedies if local retailer in a train charges above MRP? Obviously, they have to because this generally we face during our journey if there is this issue that arises. But in that case, that obviously that we have a right to deny, I would say. But the point is that in case if there are such concerns are there, then definitely they can approach to the authorities and they can inform that this is what happening. And we have now even the CCPA as well, wherein one can directly file an online complaint, because the online platform is there, wherein you can just type a message or you can just give the your information, and you can, by sitting at the that area also, you can just file a complaint and they can take the sumo to action or the action basis on your complaint as well. Yes, sir.
Sir, are unwilling, this question seems to be interesting, are
what-
unwillingly agreeing while signing an application for using the app, we have to give some extra permissions. Does it come under unfair trade practices?
Yeah,
Or any
okay,
other
okay.
liability?
So yes, yes. So here that if there are if this particular act also has been taken care for the right to privacy as well. So in case if any app or any particular such shop, they are asking for the person information, and if they share that information for some unnecessary purposes or which is without your consent, then obviously you have a right to take action against such in case if they are using your personal information. So you definitely you have a right to deny. So for example, if you visit a shop and if they ask for the mobile number, if you deny, then obviously you have a right to deny that that cannot be compulsory that you should give that mobile number to them. And even if they take that mobile number for their own purpose, then that is fine. But if they share it somewhere else, then obviously that is a breach of right to privacy. Yes, sir.
Yeah. Thank you, sir. And I guess we have covered all of our questions and entire topic. So
Okay,
is
sir.
there anything else you wanted to cover before add an additional note or something? Yes.
Okay. No, actually, the I think if the question has come, I think they have understood what I have explained, I think. And if there is, I have shared my PPT as well. So even they can use that PPT in case if they have want to go into deep in that particular topic or to research more. Because looking at the time limit what we have, so I have just restricted my focus on the recent amendments only, which are there in the Act. Yes, sir. Yes. Thank you, sir.
Yeah, and great. I would like to invite Mr. Shoaib Sheikh to deliver the vote of thanks. Over to Mr. Shoaib Sheikh. Yeah.
Thank you, sir. On behalf of Postgraduate Teaching Department of Law, Rashtra Sant Tukolji Maharaj, Nagpur University, I would like to offer deep and sincere thanks to Dr. Ajay Sonawne, sir, Assistant Professor of Department of Law, University of Delhi, who is the resource person of this national webinar on Consumer Protection Act 2019, recent amendment. Along with this, he has covered Consumer Protection Act 1986 and also covered the recent amendment till December 2021. I would also like to offer my special gratitude to the Honorable Head of the Department of Postgraduate Teaching, Department of Law, respected Dr. Payal Thaure ma'am, on her diligent efforts on conducting such a series of national webinar on law-related topics, which are very crucial not only for law students, but also for everyone. In addition, I would like to offer my special thanks to the co-convener of this national webinar, Mrs. Padma Chaubey ma'am, Assistant Professor of Postgraduate Teaching Department of Law, on making this national webinar happen. Furthermore, I would like to thank all the participants, including all respected teaching faculties and also all the students of Postgraduate Teaching Department of Law for making this national webinar successful. And last but not the least, my special thanks to our technical team headed by Mr. Abid Khan, sir, Assistant Professor of Postgraduate Teaching Department of Law, for making this national webinar serene with technical support. Thank you. Over to you, Vinay, sir.
Yeah, thank you, Mr. Shoaib. Just a note for everyone, the feedback form link has been posted in the chat box. All are hereby requested to fill the form and can leave the meeting. The link will remain active for 15 minutes.
Thank you everyone. Thank you Ajay sir. Participants, kindly fill the feedback form which is posted in your chat box. And please participants turn on your camera. We have to take one pic.
Padma, Ajay sir is there or Acha, Ajay is there? I thought you left. Okay.
Thank you everyone. Thank you participants. Thank you Ajay sir.
Thank
Special
you.
thanks
Thank
to
you,
you,
ma'am.
sir.
Thank you.
Thank you, Ajay. Thank you. Bye.
Thank you.